Hi, my name is Aaron. So initially, common law was administered by common law courts, and the Court of Chancery administered the rules of equity. The Judicature Act 1873 was enacted to fuse this split system. Section 24 of the Act authorizes judges to enforce both legal and equitable remedies, defences and claims. Where there is a conflict of common law and equitable rules, Section 25 sub 11 stipulates that equitable rules would prevail over common law. There are three views to fusion. Firstly, the orthodox perspective, also known as procedural fusion. It was meant to fuse the administration and the law, and rules remain separate. In Salt and Cooper, the aim of the Judicature Act was to fuse equity and common law business, which was mistaken as a fusion of law and rules of equity. It was just authorizing the administration of law and equity to one court. This is further elaborated by Gary Watt in the second edition of the Oxford University Press, where equity is a character of its own, compared to common law, and both survived the Judicature Acts, which unified the Court of Chancery with common law courts. Common law is a set of rules used to govern the generality of cases which provides power and rights for persons. Whereas equity limits the exercise of legal powers and rights in some circumstances. By resulting law and equity fusion involves substantive issues, key contrasts between legal and equitable ideas and solutions were blurred. The argument for procedural fusion is that there is a historical argument is that the Chancellor interfered with equity to solve common law injustices and was on a discretionary basis, basing on fairness, and was more flexible than common law judges. The wide standards and discretion is still applied today, and the methods that judges utilize and develop equitable principles is different from common law scenarios. In Walsh and Lonsdale, the defendant entered into a lease agreement with the plaintiff. The agreement stated that a year's rent is payable in advance if demanded. When the landlord demanded payment, the plaintiff refused. However, the lease was not created by a deed as required by law, so the plaintiff argued that the agreement was void. The court ruled in favor of the defendant, saying that the Judicature Acts merged common law and equity into one system, and in any conflict, equity shall prevail. According to the principle, equity looks on as done that which ought to be done. The parties were viewed as holding an enforceable lease from the date of the lease agreement. The court could order specific performance of such a lease. In addition, equity's greatest invention, which is trust, which is where a person holds property for another, therefore creating beneficial interest, which was not recognized by common law. By distinguishing legal and equitable interests, which is an example of anti-fusion, legal interests were only accepted and enforced when formalities were followed, whereas equity establishes new equitable propriety rights if there is an absence of formalities, as equity looks at the form and not the substance. It was argued that the Judicature Act was restricted to procedural fusion, and that any kind of merging of content or doctrine without a law is heresy, and this is because existing remedies are sufficient, by mixing equity would distort the way justice is done in general, and mark the end of equity in part. The idea of fusion isn't based on a wrong interpretation of the Judicature Act or confusion about the relationship between common law and equitable principles, but on the idea that the law needs to change. Secondly would be the radical view, which is that there was a merging of rules and not only administration. In United Scientific Holdings Limited versus Burnley BC, Lord Diplock said that the substantive and adjectival law systems formerly governed by courts of law and courts of chancery were merged. The Judicature Act of 1873 aimed to eliminate the gap between equity and common law. To defend this would be to misunderstand how the law in England has changed in the previous century. Lord Denning said that since the Judicature Act 1873, common law and equity had merged and became indistinguishable. In Seager and Copydex, Lord Denning said damages are available for a violation of equitable obligation, and that the judicature system has combined law and equity. The third view is an intermediate view, explained in Hanbury and Martin, Modern Equity 18th edition. It reminds us to consider the combined effect of the systems of law and equity, and to keep the systems of law separate is pedantic and is an obstacle to the development of law. And if fusion means that there are no distinctions between equitable rights and remedies and legal rights and remedies, it cannot be supported. However, Both equity and law has developed since 1873, and legal rules were sometimes influenced by the rules of equity, with the effect that a situation which would at one time have been treated differently at law and in equity is now treated in the same manner. If that is what is meant by fusion, there is evidence of it. In Tinsley and Milligan was regarding the issue of illegality. At common law, persons could acquire rights to property under illegal transactions, if they could make their own claim without relying on the illegality. Equity, however, would not tolerate this. It either barred persons or prevented an equitable remedy, provided the impropriety was specific to the claim and referred to past conduct, only relying on the unclean hands maxim that no court will lend its aid to a man who founds his cause of actions upon an illegal act. Notwithstanding the illegality issue, the court held the defendant had a right in law to assert equitable ownership based on a resulting trust, confirming the two strands of authority were molded and should be viewed as a consistent whole, as there was no logic in making a distinction. This decision was viewed as merging the unclean hand maxim into the common law rule. Lord Wilkinson explained that the convergence of law and equity has led to courts adopt a single rule for enforcing property interests obtained through an illegal transaction known as the Bowmaker's Rule. He further stated that, I therefore reached the conclusion that although there is no case overruling the White principle stated by Lord Eldon, as the law has developed, the equitable principle has become elided into the common law rule. In Harris and Digital Plus Private Limited, Sir Anthony Mason stated that there is no reason for courts to shape principles on whether remedies should come from common law or equity, and borrowing either of them would be appropriate. Also in Aquaculture Corporation and New Zealand Green Muscle Co., Cook P. stated that equity and common law have mingled or merged, and for a breach, a full range of remedies should be available regardless of its origin. Some took the view that the distinction between law and equity was simply a product of a historical development during which the procedure of the common law courts had become rigidified and needed to be supplemented by a more modern and rational court, and according to this view, both equity and common law courts applied systems of positive rules, though equities were more appropriate to modern needs, and once the common law's artificial forms and procedures were done away with, the argument went, a harmonious system would ensue naturally. Some took the view that law and equity were distinct in their very nature. Not only did they deal with different kinds of rights, seen particularly in the distinction between legal and equitable property, but the very mentality of equity was distinct. Whereas the common law refined all its issues for determination by a jury, equity probed and directed the conscience of multiple parties in a way which could not be done by a jury, but needed the discretionary powers of a judge exercised in accordance with the maxims of equity. According to the anti-fusion school of thought, the Judicature Act 1873 fused the administration of courts, but did not fuse the substantive law. Common law and equity can coexist without any conflicts, and if there are any conflicts, which is very rare, it would be resolved by Section 25 sub 11 of the Judicature Act 1873 that equity shall prevail. The decision of Cuckmere Brick Co. Limited and Mutual Finance Limited illustrated a fusion fallacy where it was criticized for importing common law duty of care into equitable duties of mortgagees. In the case of China and South Sea Bank Limited and Tan Soon Gin, recently there has been a retreat from Cuckmere. Here the Privy Council rejected the argument that the mortgagee owed a duty of care to a surety to use the power of sale before the security became worthless. They said that the tort of negligence had replaced the principles of equity, which were the basis of the surety's rights. To evaluate, one of the big differences between common law and equitable rights lies in the gaps of common law remedies. Thus, new remedies and rights were created to fill in those gaps. In the case of A.G. and Blake, Lord Nichols said, in general, legal rights and remedies are different from equitable ones. There is, therefore, however, some overlap. For example, an injunction, which is an equitable remedy, can be used to stop a nuisance or a breach of contract that is about to happen. In this case, the House of Lords allowed the equitable remedy of account of profits for a breach of contract claim when the common law remedy of damages would not have been enough. Equity has been an important part of many new remedies that have been added to common law. Unlike the common law remedies of damages, the remedies created by equity are up to the judge's decision. So a judge should decide that for a claimant to get equitable remedies, they must come to the court with clean hands and have acted fairly. However, it could be argued that while equity may not be as rigid as common law, but it does have its own rules and it must follow the same precedent rules as common law. While common law and equitable rights have become more similar, there are certain inconsistencies as shown in the maxims. Thus, equity follows the law and only intervenes when there are reasons to do so. According to Lord Justice Sir Nathan Wright, in Dudley and Dudley, stated that equity represents a later development of law, laying an additional body of rules over the existing common law, which is, in most cases, provides an adequate remedy. Equity therefore does not destroy the law, nor create it, but assist it. Therefore, there remains differences between common law and equitable rights. Equity works alongside the common law and provides different solutions to problems. Furthermore, it seems that the fusion fallacy which was illustrated in Cuckmere has not been established in England, but on the contrary, returned to orthodoxy, and this is evident as illustrated in China at South Sea Bank Limited and Tan Soon Gin. This could be further supported by Parker Tweedale and Dunbar Bank plc, where the court held that the obligations of a mortgagee were only owed to the mortgager, which arises in equity and not from the duty of care in negligence. Therefore, the Judicature Act 1873 introduced a fusion in common law and equity, but it was unclear whether the fusion was merely procedural or substantive. Thus, it is acceptable to state that equity and common law can be distinguished, as shown by the arguments that illustrate procedural fusion, where equity only fills in the gaps of law and corrects any injustices caused by common law strictness. There are cases such as Tinsley, which argues equity and common law have merged, and remedies from both should be available without questioning whether common law or equitable principles apply. Despite objections and cases that claim both common law and equity should be fused, as illustrated, most cases apply equity and its remedies only if common law provides an unfair outcome. In Malaysia, Section 3 Sub 1 of the CLA 1956, which is the Civil Law Act 1956, allows the application of UK common law, rules of equity, and certain statutes are to be applied in Malaysia, provided always that the said common law, rules of equity, and statutes of general application shall be applied on the dates specified, which were 7th April 1956 for West Malaysia, 1st December 1951 for Sabah, and 12th December 1949 for Sarawak. As far as the only circumstances of the states of Malaysia of the respective inhabitants permit, and subject to such qualifications as local circumstances render necessary. Section 3 Sub 2 of the same Act stipulates that in the event of conflict or disagreement between common law and the rules of equity with reference to the same topic, the rules of equity shall prevail. In Jamal bin Harun and Yang Kamsia binti Mur Rasli and another, it was stated that their lordships agree that it's up to Malaysian courts to decide, subject to federation law, whether to follow English case law. Modern English authorities are persuasive but non-binding. In deciding whether to accept their guidance, the courts will consider Malaysia's circumstances and apply them only to the degree that written law permits and no further than they deem just. The federal court can decide whether to accept modern English authority. There were applications for the repeal of Section 3 of the CLA 1956. One would be from the late Professor Ahmad Ibrahim. He stated that when there is a gap, Malaysian courts should not look to English common law but rather explore for local remedies within Malaysian legislation and court decisions which would emphasize local situations and people. We may still need to refer to the common law of England for tort cases, and we may still need to refer to rules of equity for cases regarding the trust law of trust. It provides guidance to the court in applying such rules, leading to greater consistency. A case illustrating the rules of equity and law of England being applied in Malaysia would be Chin Jin Tian and another, and Chin Huat Yen and another, which was regarding whether the concept of secret trust in a will is recognized in Malaysia. Here, the court held that by virtue of Section 3 Sub 1 of the CLA, the law of England and rules of equity are applied and followed the concept of secret trust, which was governed by the rules of equity and law of England. The court upholds secret trust to prevent fraud and on the testator and compel the trustee to fulfill his obligations. In Tun Dr. Mahathir bin Muhammad and others, and Datuk Seri Muhammad Najib bin Tun Haji Abdul Razak, it established that to prove the tort of misfeasance in public office, it must be proven that the defendant is a public officer, and this derives from the Three Rivers District Council and others, and Bank of England, which was referred to by the judges of this case. The question was whether the meaning of a public officer extends to the Prime Minister of Malaysia, who was the defendant. It was concluded that Articles 132 Sub 2 Sub A and 160 of the Federal Constitution does not constitute a Prime Minister as a public officer. Now, to illustrate the application of rules of English equity being applied in Malaysia would be illustrated by Ramsden and Dyson, where it was established that a tenant may rely on equity to enforce his tenancy if there was expectation encouragement created by the landlord and there was expenditure by the tenant. This was imported and accepted in MPRL, Karupan Chetty and Swathian, and later applied in Devi and Francis. In Syarikat Batu Sinar Sdn Berhad and UMBC Finance Berhad, the judge advised Malaysian judges to develop Malaysian common law by focusing on local conditions. Gopur Suriram JCA in Tengku Abdullah Ibni Sultan Abu Bakar and Muhammad Latif bin Shah Muhammad warned against blindly copying English or common law legal rulings without considering the local circumstances and residents. The lawsuit involved Section 16 of the 1950 Contracts Act, since the legislative meaning of undue influence is the same as the English doctrine. As the judge stated, Malaysian decisions shouldn't be based solely on English or Commonwealth rules without considering local circumstances and population. Which we may look to similar court rulings, we must consider our own statute and moral standards. It's unwise to blindly accept foreign decisions that conflict with our own values. As the country's highest court, the Federal Court may develop Malaysian common law by considering local circumstances and inhabitants. Section 3 prescribes how to establish Malaysian common law. In Napline Sdn Berhad and Jones Lang Woodton, Dato Abdul Hamid Muhammad J. explained the correct methodology. The court should first examine whether there is any written legislation in force in Malaysia. If so, the court can stop looking. If none exists, the court should consider common law and equity rules. The court should evaluate whether local circumstances and local inhabitants allow it. Since there is no written law in Malaysia, the court can create its own common law if it rejects it in whole or in part. To apply English law in Malaysia, it must pass three statutory hurdles outlined in Section 3: cut-off dates, local conditions, and local inhabitants. The court will apply English law if it passes these three tests. To evaluate on how the Judicature Act 1873 affects Malaysian law, Malaysia's legal system derives from England as it was an English colony. Thus, laws and rules have been imported here, but since our independence in 1957, we have developed our own legal system. English law still plays a significant role when Malaysian legislation is absent. After satisfying Section 3 of the Civil Law Act 1956, courts can still use English rules of equity and common law. The English Judicature Act showed both substantive and procedural fusion, although, as noted, the application of common law and equity leans towards procedural fusion, where equity fills in the gaps of common law, and only the administration of equity and common law have been fused. However, as mentioned, the application of common law and rules of equity is ultimately still a non-binding feature in Malaysian law. In conclusion, Lord Deep Locke's view that the Judicature Act 1873 fused equity and common law would be partially true, as illustrated in England. There were some circumstances that common law and equity were simultaneously used to create remedies, which illustrates substantive fusion. However, the courts retreated from this approach and followed the orthodox way of applying common law and equity. With this said, Malaysia, where our own domestic laws are available for cases, it will be applied. Malaysian courts only uses the rules of equity and common law to fill in the gaps where domestic law is not available. This illustrates that Malaysia applies procedural fusion.